parts of her kit for her passive is on enemy death, she will heal herself for 10% max health, and then she'll attack the most injured enemy for 300% damage and clear 3 positive effects. So if you are fighting in something where there's like a lot of summons or like, you know, extra little guys to kill, like in raid nodes, then this will proc a lot and it'll do a lot of healing and a lot of extra damage in there.
What's going on, YouTube? This is Professor Magnum. We're going to talk to you today about the Deathpool controversy. For those of you who don't know, as originally marketed, Deathpool was supposed to initiate a passive attack of 300% damage on an enemy death. As originally provided for in her kit, there was no limitation on the activation of that passive attack. So the reader would think that would include deaths procured by Deathpool herself, meaning if she kills somebody, it should trigger her passive attack. Of course, she was released. We started playing with her and we realized that that was not the case, that she wasn't triggering that passive attack in the event that she killed an enemy. And this caused some degree of complaint on Reddit and I'm sure through other avenues. And the result was Scopely went in and changed the passive ability to now, open quote, clarify, close quote, that Deathpool cannot herself animate her own passive ability, meaning she cannot be the catalyst of her own passive attack. Now, a couple things here. First thing is, probably not a huge deal in terms of practicality, meaning, will it make a massive difference in the play of the character? No, probably not. However, as a matter of principle, this is a significant modification to a product which people have purchased. Some people have purchased it through money, some people have purchased it through the use of time, and some people have purchased it through both methods. And the end result is people who invest in the product with an expectation that it will perform as marketed are going to be disappointed in that the product does not actually deliver on what it was marketed to deliver. So that begs the question, and Reddit is on fire today, what are the legal ramifications of all of this? Well, a couple things there. So in my real life, I'm actually a lawyer. And I've done civil rights litigation, I've done Consumer Protection Act litigation, and so I have some familiarity with these topics. And there's a couple things here. So the first thing is, what remedies would exist would begin with the sources, meaning you could go to Scopely or Google or Apple and try and seek a refund. I've heard Scopely is exceedingly tight-fisted when it comes to that, but anecdotal suggestions have indicated that Apple and Google actually do issue refunds for these sorts of post hoc changes to purchases made by mobile gaming companies. Now, let's say that's a dead end. Could you theoretically have a lawsuit against Scopely for retroactively modifying a product? Or for those who would say, well, she's not been changed, it's just the description that's been changed, making a false representation or a false advertisement as to a product? And the answer is maybe. So, as all of you are aware or should be aware, there are terms of service associated with the use of your account. And oftentimes those terms of service will limit the remedies available to the participants of a game, and also include arbitration provisions, and if not arbitration provisions, what are called form selection provisions, which mean that the terms of service can dictate where a lawsuit will take place, if at all. Now, courts have differing opinions on how enforceable these types of provisions are, but as a matter of theory, if you could get past the terms of service, yes, there would be an actionable claim there. And that could be under what's called the common law. This is the body of law that we've inherited from English descent. That includes claims like fraud and things of that nature. Or most states have enacted consumer protection laws, which prohibit misleading or fraudulent representations in connection with consumer transactions, and this would fit the bill as well. It would be interesting to see what states Scopely could actually be sued in, because we have this concept in the law called personal jurisdiction. And for personal jurisdiction to be satisfied, you have to prove that someone has availed themselves of the benefits of operating in a particular state. And unfortunately, the law is very slowly developing how that applies in a Amazonian economy where everyone does all their transactions online now, and no particular state is favored by the vendor versus any other. Our law is just not very well equipped to deal with that scenario, but that's the one that we're facing. So very interesting questions. And what I'm going to do is I'm going to flag down some other lawyers who have thoughts on this, and then maybe we'll come back and do a more in-depth discussion of it, or post some additional thoughts on it. If you think that that would be interesting to hear, even if you ultimately aren't going to find a lawyer over this situation, let us know, make a post in the comments, and if you like this content, like and subscribe. All right, thank you so much.